You were just injured in a car crash where the other driver clearly ran the red light or was speeding. Why didn't that driver get a ticket from the officer when they arrived? Hi, I'm Frank Nunes. I'm a California personal injury trial attorney practicing in the state of California. Join me as we answer that question. So many times clients come to my office and they say, I know the other driver ran the red light. I know he or she was speeding. I know they made an improper turn, but the officer didn't give them a citation, and that frustrates them to no end. Why does that happen? Well, in California, most often the law requires that the officer observe the crime committed in his or her presence, particularly in traffic cases where the violation, such as running a red light, speeding, or making an improper left turn, is an infraction. It must be committed in the officer's presence under the criminal standards in order for that conviction to hold up in the criminal traffic courts. So that's why a lot of times when the officer gets there, the cars have already been in their places of rest after the collision. One party says the other party ran the red light, the other party may admit it or may dispute it, but the officer looks at it and says, well, I didn't see either party run the red light, so I can't issue a citation for it. And even if a citation is issued, it isn't always the end-all be-all. While the issuance of a citation to a driver can give rise to a presumption of negligence in California, it's not necessarily required to proceed with a civil case against the careless driver. On the other hand, certain offenses are more serious if they rise to the level above an infraction, which is a misdemeanor, which typically in California is a crime or offense punishable by up to 1 year in jail. Then the officer does not necessarily have to see it committed in his or her presence to issue a citation. The most common example of this is a crash caused by an impaired driver. The officer will arrive at the scene, take statements from the parties, form a reasonable suspicion that one of the drivers involved may or may not have been impaired, and then begin to question and investigate that potentially impaired driver to a higher level to determine if in fact that person was impaired at the time of the collision. In those situations, the officer will arrest that person for driving under the influence if there is probable cause to do so. Felonies, the largest, most serious offense in California, crimes that are punishable by over a year, those can be arrested whether or not committed in the officer's presence. Well, that's it for a brief overview of why the officer didn't cite the at-fault driver. By the way, if you found today's information helpful, subscribe to our YouTube channel. Why? So you can continue to get great new content every time we publish another great educational video. And if you have questions, I want you to pick up the phone and call me. I can answer your questions. I answer questions like this every day. You can reach me at 559-436-0850. I'm Frank Nunes, and thanks for watching.